All right, I know everybody wants to get to lunch, wherever lunch may be. We're still handing out some substitutes for y'all to look at, but while we're waiting on that, we'll talk about a few of them. And Chairman Jaspers, why don't you talk to us about SB 15?
Thank you, Mr. Chairman. It's good to be in front of you guys this year for the first time. SB 15 is their school safety bill. It's the combination work of the Senate School Safety Study Committee and our House School Safety Study Committee that met last summer and fall. It's a combination bill. You know, it passed out of committee last week. We had one change we needed to make. You get into one of these things with the Sheriff's Association and the GBI, and the GBI needed to win. They added something to it, but really what it does, it adds, formalizes site assessments in schools and the procedure to do so. Formalizes with a school safety officer or in the schools. That the principal is going to be the key person to evaluate what goes on in schools as they are now. These are just formalizing what really are now. It increases the communications between GBI, GSACs, DOE, and local law enforcement. And it adds three things to what the school safety plan must have in it. We'll look forward to next year adding a little bit more teeth into the bill, but this is where we're at today. Thank you, Mr. Chairman.
Chairman Setzler.
Thank you, Mr. Chairman. To the chairman, what impact does this have on private schools? I know the discussion's been largely around public schools, but what impact is
it has, Chairman Setzler, it has no impact on private schools. Okay. It should, but it does not. That's my personal opinion.
Okay, thank you.
Leader Trammell.
Thank you, Mr. Chairman. The question I have is about lines 143 to 145, the reporting requirement, reasonable suspicion of student criminal activity. And I guess the question I have is, isn't the intent of the bill to basically address suspected violent activity? And isn't this language, won't it capture any criminal activity whatsoever?
Well, I think you're right, but I think any criminal activity could lead to further. I think what we'd like to do on this bill is that if there's a criminal activity that's going to be reported, it goes back to the principal just as it is now, that they get to decide, and then it will be further moved on. Go ahead.
Mr. Chairman, if I could ask.
And I will say I'm not an attorney, so reasonable suspicion, we've got people in here who can talk about that, but I'm not.
If I could ask a follow-up question, but I mean, it wouldn't be your intent to, if one student, for example, took something from another student, technically that might be criminal activity, but that's not what you're trying to capture in terms of reporting to law enforcement authority, is it?
Well, if you look earlier in the bill, it's putting that responsibility on the school principal. And I think they're the ones who filter that now, and it just formalizes that how they're going to approach it and take care of it. So on 132, it talks about, each principal of the public school shall serve as a school safety coordinator. They're the filter. They're the filter today.
Mr. Chairman, if I might, would you be open to something, an amendment to narrow it to suspicion of, again, violent criminal activity as opposed to just regular run-of-the-mill students getting in trouble in school?
Well, I think, Mr. Leader, the school principal should be the decider of that. They're the ones going to have the touch, and every school is different, and every school has a different feel, and that's what the principal does. And I really rely on them and the goodwill that they do every day to make sure we keep our schools safe.
Representative Hughley.
Thank you, Mr. Chairman. To Mr. Chairman, the leader is talking about or asking about what I'm concerned about as well. But my question to you is, because we're putting this in law, that they should report suspicion of any criminal activity, is there any liability if they don't report something that they should have known or should have reported? Are we creating a liability situation for these principals?
No, ma'am, I don't know that answer. That's a very legal question. I don't know. But I think even today, a school principal is liable for everything that happens in their school.
So then wouldn't it be true that if we address what Leader Trammell is saying and narrow that some, we would take away some of that liability associated with not reporting in the principal's discretion away from the people that we are charging with this responsibility?
No, ma'am, I think they're still going to be liable. I think at every school mass shooting or wherever, it really first thing it falls to is the principal, or any violence, it goes to them first. And I hate to limit any power that they have to report because they know.
One final thing, and I'm just going to say it this way. Citizens in the minority community are concerned about school to prison pipelines. And if this responsibility is not used correctly, then minority students will be adversely affected, and they'll go right from the classroom to the jailhouse for some things that would not otherwise have caused that. And so that is my concern, and that's why narrowing the language is of concern to me.
Thank you.
Whip Kelly.
Thank you, Mr. Chairman. Chairman Jaspers, wouldn't you agree now that there's responsibility on school personnel and especially a principal that if there's criminal activity going on at their school or suspicion of criminal activity going on at their school, that the responsible thing to do of any administrator who is worth their salt would be to report the criminal activity that exists so that you don't have our school systems being a breeding ground for criminal activity? Wouldn't that be the proper thing to do now? And
Yes,
that's
sir.
all we're doing is codifying that?
Yes, sir.
Chairman Fleming. Wave. Chairman Taylor.
Mr. Chairman, just a question to the author. In looking at these same lines, when I saw the criminal activity, I have a great concern of drugs in the school, and that is nonviolent. So if you change that wording, it could leave out something like drugs, which are a problem in schools today. The same thing with extortion that doesn't get to violence, but it still needs to be addressed in our schools. Is that correct?
Yes, ma'am. Thank you.
Thank you.
Okay, we've got a few more that want to ask questions, but I think it's been discussed enough. Got a few more bills we need to talk about. So thank you, sir.
Yes, sir. Thank you. Thank you, Rules Committee.
All right, Chairman Martin, talk to us about SB 71.
Thank you, Mr. Chairman. SB 71 is LC 392399, as this was the proposition that we brought earlier this year on House Bill 89 out of Chairman Smith's Special Access to Quality Health Care Committee with two changes. It changes on line 12, the 6 ORs to 4, and it also limits to a single specialty freestanding ambulatory surgery center. Mr. Chairman, if you will recall, this is to bring Dr. Andrews' group to Georgia. They had received their CON twice. I can get into the details if you would like, but basically they were given an atypical exemption, and that was overturned in court on the basis of the Commissioner of Community Health related that the quality available through this special integrated center would fit the atypical need and get through the rule. A judge decided that he knew more than the Commissioner of Community Health and thought the quality, while better and unique, was not necessary because just okay was okay for Georgia. And we do have quality health care, but this is a unique opportunity for Georgia. And I would just remind the committee members, they have been awarded twice by the department and executive department of this state. And I would also remind the members that they would not require a CON. They would fall under paragraph 18 of the current code section were they not trying to teach and do fellowship teaching in Georgia to help our other hospitals? So if they were just trying to open a 2 OR single specialty center, they would not even require this, but because they're trying to do more for Georgians in Georgia, they are trying to get open, bring economic development and teaching to Georgia. So I'd ask the committee's favorable consideration to move this to the floor.
Representative Beverly.
Thank you, Mr. Chairman. A couple questions for the gentleman, if you yield. Number one is on line 12 through 15. The question is Integrated Ambulatory Surgery Center is going to be developed on the same site as a sports training and educational facility that includes sports training facilities and fields. Does this open it up to putting a facility on a private or a public school?
Does it open it up?
Yeah, so that in essence, it's an integrated ambulatory surgery center could, by the language of this bill, they could literally put one of these places on a private or a public high school, if you will.
I don't believe that they would be able to do that on a public school certainly without the coordination with the school board in the various area. On a private school, I suspect they could do that. They could open that facility now as long as they dealt with all the rules and regulations that are required for the private schools operating.
Thanks. And then, gentlemen, further, I have one other question for you.
Sure.
On lines 18, basically on lines 18, it says, well, 16 through 18, a community education program for student athletic programs on injury prevention and treatment, and then it says that provides care to Medicaid patients. So this thing will go into if the facility provides medical care. So it doesn't necessarily mandate, this bill doesn't mandate that you have to take Medicaid patients.
It actually does. If you go back on the indigent care, also on line 32 of the bill, they have to do equal to or greater amount of 5% of their gross revenue.
Yeah, but
that would do that. So they would take people that did not have that were not paying clients. So I would certainly think if they had folks that would take Medicaid, if they fit into this and provided this type of care, that they would provide it for Medicaid. This is basically mapping paragraph 18 of the current exemption, except paragraph 18 only requires that center for that exemption to provide 2%, so they're providing actually 3%.
That's just a point of clarification, distinction. There's a big difference between indigent and Medicaid. And
I understand that, absolutely.
So in the language of this bill, it seems as if a facility could open up, and just sort of stone's throw away from your imagination. If a facility opens up and there are kids who are in high school who potentially have Medicaid, they would be excluded from being there if this facility decides that they don't want to see those patients, and they're not under any obligation to see them at all.
Well, the way I read the bill, if I may, Doctor, is it provides athletic programs, and I'm on line 17, student athletic programs for energy prevention and treatment related topics, and provides care to Medicaid patients. So it does provide care to Medicaid patients. And if the facility provides medical treatment to children, then it would also do that to Peach Care for Kids. So it does provide to Medicaid patients. It also provides indigent care, and all it's saying there, if the facility doesn't provide care, if it's not authorized and accredited for care to children, then it wouldn't obviously be able to treat Peach Care for Kids. But if it does treat children, it would also treat kids covered by Peach Care for Kids.
All right, hand your mic to Mr. Bodie.
Thank you so. Thank you so much, Mr. Chair. To the gentleman, is it not true that two hospitals, Northside Hospital and Wellstar Roswell, I believe, both objected to Legacy Sports being able to build their facility in North Fulton? Is that not true?
I'm going to have to share the mic with you. We're going to have to do a duet. That is true, and it's further true that in the past that Wellstar, it was at North Fulton at the time, a tenant hospital objected to North Side when they wished to open ambulatory surgery units in North Fulton. When I was the mayor, I testified on North Side behalf. When Wellstar objected, I've also testified on, again, Wellstar was North Fulton at the time, on their behalf when Northside object. It seems that to be kind of common around there that if you've got the monopoly in the area, you object to anybody else providing care.
this gentleman further here. Is it not true that one of the reasons why those two hospitals objected is that the legacy facility could possibly gross over $100 million, and that way affect the revenue stream of those two particular hospitals that objected in the first place?
I don't know the business model, but again, I would say to the gentleman, if Dr. Andrews wanted to open a single specialty ambulatory surgery center and just churn money out of North Fulton, they could do that under paragraph 18 of the current LNR. They could open with 2 surgery rooms. He could open 4 years ago when his first CON was done. So if he were interested in just doing surgeries and not teaching so that it would be to the benefit of our other hospitals and other Georgians, he would have opened in 2015 or 2016. So it's not an issue of money in this particular space to me. It's an issue of opportunity that we have to bring something unique, and that's the reason they were granted the CON twice under the atypical, exceeding the atypical barrier for quality, the unique quality that they deliver.
Chairman Fleming, tell us about 162.
Thank you, Mr. Chairman. Senate Bill 162, which I know is in the books, and I'm assuming it was passed out.
Just tell us about the bill.
Okay. Senate Bill 162 is a Senate bill that was stripped in Energy, Utilities, and Telecommunications because the author did not desire to use it anymore. And the issue of the regulation of Airbnb and other short-term rental companies, a provision was included regarding that. As many members of the body are aware, there have been study committees and several bills dropped. None have had any success with passing to prevent local governments from completely, I guess you would say, regulating out short-term rentals, Airbnb, Expedia, things like that. Senate Bill 162 simply says that a local government may not completely, by regulations, ban the short-term rental process. There unfortunately have been some local governments accused of doing that. It is a very mild step, if you would say, to tell local governments you cannot completely ban this if you attempt to regulate it, and I would appreciate the committee considering it.
No questions. Chairman Stevens, tell us about H.R. 48.
Mr. Chairman, H.R. 48 is the most comprehensive anti-drilling, anti-seismic testing resolution that we've had to date, and we've gotten the coastal delegation, those that are here, to sign that.
Is this an urging resolution?
An urging resolution, yes, sir.
You have no questions. Chairman Tanner, tell us about SB 200.
Thank you, Mr. Chairman. Senate Bill 200 has several provisions on it. It has the provision that came over from the Senate, which deals with if a low bid is rejected by GDOT, then that low bidder would have a right to appeal. It also has House Bill 511 on it with a couple of changes. Just keep in mind, 511 was one of our House priorities this year that primarily dealt with rural transit and rural communities and removing barriers, transportation. But one of the complaints and concerns we've had raised by several people, including GDOT, was CERTA was being administratively moved from GDOT, and we've left, so we're leaving CERTA at GDOT. One of the other things that we did in the bill was we had a flat tax. If tax was collected on Uber, Lyft, rideshare companies, taxis, we've changed that flat tax to 50 cents rideshare fee in this legislation. This legislation also has the governor's jet fuel bill exemption as it passed the House at the .005. I know there's been a lot of conversations around that. But again, that's what the substitute to Senate Bill 200 does, and I'm asking you to let me move forward and try to get to conference.
And there's nothing in there about Gwinnett County, correct?
Correct. No, there's not.
Okay. Chairman Knight.
Thank you, Mr. Chairman. As part of SB 200, I know we had put in the jet fuel exemption, and I think this Rules Committee and everybody in the body has made note that I've been very supportive of the mechanism by which we have, but it has been inadequate as far as our funding of all of our general aviation airports, including regional airports by which these commercial airlines fly into, and to many of the airports that are called reliever airports by which charter jet flights fly into, relieving the congestion at Hartsfield. And I've made a motion, or gone up and asked these members to move this forward as a negotiating tool, but so far there's been nothing in it from the House that shows any inkling of a negotiating, because we're still at a half a penny. And I just want to make sure everyone knows that under the current proposal, between what we do, which was the state exemption, is about $47,700,000, plus in addition to what we did as a body in the special session, which was $25,466,000 that we've exempted at the local level, we would now come up to $73 million in exemption on jet fuel. In exchange for that, we get $3 million under this current bill. And this is not a win-win for everyone around the state, especially those who've made a good faith effort, you know, to try to come up with a win-win situation. And as Chairman Chokas had said on the floor, you know, those executives don't take the Greyhound bus into his area. But with that, at the appropriate time, I'd like to make a motion to amend, if that's in order here, so that maybe we could start from a negotiating point on this bill.
Did I hear amend?
If that's proper, I'd like to make a motion to make an
Not
amendment.
unless it's in writing. So I'll rule that out of order. You have no other questions, Mr. Tanner. Chairman Ballinger, tell us about the substitute to 190.
Thank you, Mr. Chairman. Senate Bill 190 just it updates the definition for legal custody and physical custody. And on lines 50 and 51, it just allows for a counterclaim if there has been a petition for modification of legal custody or physical custody.
You have no questions.
Thank you.
Chairman Knight, tell us about 171.
171, Mr. Chairman, this is the raise for the constitutional officers, the COAG bill, as many would see it. I know that it had come over, it needed some work. I know you've been involved to help make sure that everything is worked out. Basically, this bill rolls all the past COLAs into the base, so that there's no calculation, and we don't have to go back and calculate every year. And it's got the 5% increase for our constitutional officers. And I will point to everyone on page 10, line 342, that we have moved the effective date to January 1 of the second year after which the census is conducted. That's in an effort to make sure that we give our local governments adequate time to prepare budgetarily for those raises, which I would say, if you look at the tier system, these raises in whole are not a large amount of money.
You have no questions. All right, let's set us a calendar. HR 48, it's on. SB 15, it's on. SB 162. It's on. SB 171. It's on. SB 200. It's on. SB 71. All right, there's a rejection. All right, all in favor of SB 71 being placed on the floor, say aye. Aye. Opposed? No. All right, we're going to do a division of the House. All in favor of SB 71 being placed on the floor, raise your hand. And those opposed? It is not on the floor. SB 190. It's on. SB 162, I already did. So let's check. SB 200, SB 171, SB 15, SB 190, HR 48, and SB 162. Does that agree with everybody's list? Okay, we may. Yes, sir.
Mr. Chairman, I'd like to make a motion.
Yeah.
A motion pursuant to Rule 33 with respect to SB 50. I'm not sure what the rule is that it's presently under, but would make a motion to move SB 15 to modified open.
All right, there's a motion to move SB 15 to modified open from modified structure. There's an objection. All in favor of moving it to modified open will raise your hand. Those opposed? It does not move. There's a recognize the vice chair for a motion.
Thank you, Mr. Chairman. I move that according to Rule 33 that all debate be limited to 1 hour on all bills on all calendars today to be decided at the discretion of the speaker.
Is there objection? Okay, there's objection. All in favor of the motion, raise your hand. Opposed? Motion is adopted. Any other business? We're adjourned.